This presentation will go over how and when to use common contract clause. The first thing we'll discuss is what is a contract clause. So each section of a contract is called a clause. Each clause addresses a specific need, privilege, right, duty, or deadline. What's the difference between a clause versus a boilerplate clause? So a clause is any section of the contract. A general or boilerplate clause typically uses similar language from contract to contract. These are standard in most contracts, but not all. A standard contract has these 7 following sections: the opening paragraph, which identifies the parties, the purposed clause or the recitals. This is optional. Then it moves on to the operative provisions, the remedial provisions, closing provisions, signatures, and then finally, if there are any schedules and attachments. So when looking at this template, there's going to be different sections with different clauses in them. The beginning of the section will say what the clause is about, and then they'll give an example clause. So what are you to do? You'll read the description of the clause and determine if this is added to your contract, if it would give additional protection from liability. What you'll do is then go to the example clause below. You'll copy and paste this into your contract, put the heading just as it is, and then read this clause. There may be some sections where you need to change this to customize your contract better. Do you need to add them all? You don't. Not every single clause needs to be included. This is customizable to what you think will fit your business needs best. The first clause that you'll see is a dispute resolution and arbitration clause. These clauses are separate and they dictate how and where a disagreement between the parties will be settled. Defining these terms within the contract allow the parties to agree how disputes will be handled before they occur. Including this in the contract will give you private processes that avoid going to court. The example clause is listed below. The next clause is called an indemnification clause. This obligates one or both parties of the contract to compensate the other party for harm or losses caused by a third party. So, example of changing this would be if you read this and you say that you would like to only obligate the other party, you would read this and make sure the language fits that. If you would like both parties, which in some contracts, the other party that's negotiating will come back and say that they'd like both parties to be indemnified, then you'll change it to fit that. The next clause is the jurisdiction and the governing law. Jurisdiction and governing law clauses decide what law will govern the contract. Each state has different law. This is usually the state or federal law that governs. Since we are in Ohio, Ohio is the most favorable and logical choice for companies registered here. The next clause is the force majeure clause. A force majeure clause is included to relieve a party from performing its obligations under the contract in certain conditions outside of the party's control. Many people were happy that they had this in their contracts during the pandemic, because that is one of the conditions that are included below. And on the next slide, you'll be able to see the example clause. An assignment clause can either allow or not allow a contract to be assigned to another party. Assigning a contract is when the original consumer lets another party take over the contract. So an example is, most people have 12-month leases on their apartments. Let's say you needed to move in month 10, but you could not terminate the lease. So you had to move into a different apartment, but you still had 2 months left. So you find a friend or a third party to move into your apartment for those 2 months. If there's an assignment clause and it allows you to assign it to that friend or third party, you as the original tenant are no longer liable for rent or that apartment. If there's a clause that says you are not allowed to assign, that means you could not do that and you will still be liable for the rent in the apartment. So this is something that you need to think about if you would allow or not allow your lease or contract to be assigned to someone else. This is the assignment clause that we provided. It states that this agreement may not be assigned by either party voluntarily or by operation of law to any other person, entity, firm, or corporation in whole or in part without the express written approval of the other party. So many times you see this, that one party would like to assign it to someone else, and that's okay in the contract, but you need express written approval of the other party to assign it. So that way that both parties agree on this assignment. Notice is the next clause. Notice describes the exact way that the parties must communicate with each other. If one party is required to give notice by mail and gives notice verbally, they're in breach of this clause. So this clause decides how and when each party will reach out to the other one to not breach the contract. And this is one where you can edit it to say mail, verbal, written, different things like that. Many times people include a headings clause. So the headings or titles for each section make them easier to identify and locate in the contract. A headings clause clarifies that the wording of any headings or titles are not substantive to the contract sections. So if we go back to the assignment clause, the heading says no assignment. But if you read the clause, it says there is no direct assignment unless both parties agree. So that's an example that you cannot take the heading as a substantive of what the actual clause will say. The next section is severability. Sometimes in contracts, certain portions or sections of the contract become unenforceable. Including this clause will make sure that the rest of the contract will still be enforceable. The next clause is called an amendments clause. Amendments are alterations, modifications, or supplements to an agreement after it has been fully executed. This amendments clause example says that the agreement may be amended only by a written instrument signed by both parties. Any amendments shall be attached to this agreement and incorporated herein. This means that any agreement, alteration, modification, or supplement to this agreement after it's been fully executed by you and the other party can be added, but it must be in written form and signed by both parties so that you agree. It should be attached to this agreement and it will be incorporated. The Counterparts on PDF Signature clause is a modern clause that allows people to sign documents online and in different places. A counterparts clause allows the parties to execute the agreement in separate multiple copies. Each copy is known as the counterpart. We have now gone through all of the clauses, and I would like to just read the disclaimer at the end. These files were created and reviewed by students and supervising attorneys at the University of Akron School of Law, Small Entrepreneur and Economic Development Legal Clinic. These community resources were designed to educate and inform entrepreneurs and early-stage startup businesses. Therefore, they may omit terms or language relevant to specific situations and circumstances. The law reflects individual and personal facts and circumstances. Therefore, legal resources like these cannot be structured to fit every circumstance. Although the Seed Legal Clinic takes reasonable efforts to update its resources and to provide current information, this document, the templates, and information provided are not legal advice and are not guaranteed to be complete or current. Any use of these resources does not create an attorney-client relationship between its users and the Seed Legal Clinic, nor does it constitute legal advice or other professional advice. It is advised to consult with a licensed attorney before using these forms. The user of these forms and resources assumes all risk and liability that may result from their use.